This is a video lecture on sex discrimination in employment. Now I may skip some of the slides just to hold down the length of the lecture. Why do we need the laws against sex discrimination? Well, we have had a historic problem. We've talked about the historic problem against women. That's why we have intermediate scrutiny. Pay inequities, discrimination in hiring and promoting, discrimination in benefits, sexual stereotyping, which is becoming more of a problem. Sexual harassment and the inequities attendant thereto, and discrimination based on pregnancy. All of those are relevant in sex discrimination. The statutory authority will begin with Title VII of the 1964 Civil Rights Act. Title VII was amended by the Civil Rights Act of 1991 that affects punitive damages. Pregnancy Discrimination Act of 1968 that also amends Title VII. The Equal Pay Act of 1963 that then amended the Fair Labor Standards Act, and then the Fair Labor the Equal Pay Act was amended in 2009 by the Lilly-Ledbetter Equal Pay Act, which I believe was the very first piece of legislation that President Obama signed to come out of Congress. Tennessee Human Rights Act locally, but states commonly have their own civil rights statutes and may provide additional protection to additional employee groups, such as sexual preference or sexual orientation protection that's given to that's provided by, I think, 21 states, and I'm not sure when it will become federal protected class in the employment setting, but it's probably just a matter of time. Let's look at Title VII. We've talked about Title VII from an overview applying to 15 or more employees. It applies to labor unions, governments, and employment agencies in addition to employers. It gives protection to U.S. citizens and resident aliens working in the United States. It applies to U.S. citizens working abroad, right? Working for U.S. companies in foreign countries. It prohibits discrimination in employment based on race, color, national origin, religion, and sex. Sex here meaning gender. Protects females and males. And protects employees and job applicants. May even protect after an employee leaves the employer. Employers can't discriminate under Title VII based on sex, because of sex, in any of the following: in hiring and training, promotion, demotion, transfer, duty assignments, supervision or management treatment, benefits, retirement, pay, or other conditions of employment. Let's take, for example, a case out of Tennessee under the Tennessee Human Rights Act. And as I explained before, the Tennessee Human Rights Act is a state provision covering 8 or more employees. And it gives all of the protections that the federal anti-discrimination laws give. And the Tennessee Civil Rights Act was construed by the Tennessee Supreme Court to protect against a condition of employment. For example, in this particular case of the cold shoulder, a worker, a female employee, applied, said that she was sexually harassed by her supervisor, and she reported it. The The employer, the supervisor, then told all of his employees, the co-workers and subordinates about it, and the word kind of spread within the department or within the company that she had done this, that she had filed a claim. And of course, his argument was that it was untruthful. Apparently, other workers thought that it was untruthful as well, and they started giving this claimant the cold shoulder. And basically, is you're ostracized. You're not treated as one of us. And a court held that this cold shoulder treatment affected her condition of employment and therefore was actionable. It would be retaliation. Discrimination in the selection process. As I said, it was prohibited under Title VII. It prohibits advertisements that are discriminatory against women. And by the way, this is the same general provision that you would have for Age Discrimination in Employment Act or Americans with Disabilities Act. If the advertisement was specific and showed an animus toward the group. All right, saying the advertisement is for the Girl Friday wanted. Now, you don't see these anymore, and for good reason, but it used to be a Girl Friday was a woman who worked in the company, and she would do all kinds of administrative type tasks. She would go get this, she would file this, she would type this, she would do everything within it. Friday, remember Robinson Crusoe. An ad, construction workers needed. Men only should apply. All right? You can see how, on its face, how problematic that is. How exclusionary that is. You can have sex plus sex discrimination. Sex plus sex discrimination. So in addition to the gender factors may cause an employer to discriminate, they look at other things that they're that they don't want, that may indicate that it is gender that's the problem. All right. For example, an employer doesn't want to hire someone that has small children, or being of childbearing age, or don't want to hire someone because of taking care of elderly parents. Well, keep in mind, look at who does these things. They're women, right? They are women. Women are the caregivers for the elderly. They're generally the caregivers, usually the caregivers for small children. And, of course, women are the only child bearers. Fetal protection policies are prohibited by the U.S. Supreme Court in Johnson Controls versus United Auto Workers. These are policies, employment policies established by employers where they discriminate against women because the concern is that having a woman work in a particular department where there's a higher risk for her to have stillbirths or to have children, babies that have deformities, i.e. the fetal protection, that these are discriminatory. And in Johnson Controls, the Supreme Court said Title VII protects women. It does not protect the infants. And it was discriminatory. And the policies were struck down. Employers can look for certain persons or persons with certain characteristics when they establish bona fide occupational qualifications, or simply BFOQ, bona fide occupational qualifications. You can have a BFOQ, when this becomes a requirement for the job based on education, height, weight, strength, physical appearance requirements. But in order for a BFOQ to be upheld as non-discriminatory, the employer has to be able to prove that the BFOQ is essential to the specific job, a requirement. The BFOQ must be essential to the specific job. You can't do the job without this trait or characteristic. Sometimes employers simply will not accept application or seek application from women based on a BFOQ. Well, under limited situations, they can do that. They can refuse to accept job applications for women, but the employer would have to show that a substantial majority of all women who would apply would not have the physical capabilities to perform the duties required. If you're talking about very heavy lifting, right, the strength requirements, then that may very well be the case. Employers cannot mislead women into thinking they can't perform the work. Simply telling them you can't, we usually hire men because men can lift more, etc. Well, perhaps the men don't actually do that much lifting. So you can't lie about it. Continuing on with BFOQs, gender, like national origin and religion, can be a BFOQ. Physical condition and age can be as well. Race cannot be a BFOQ. A specific gender may very well be required as a BFOQ for authenticity and moral concerns. Think of this. Ladies, who would you want to be working in a department store that had ladies' clothing and ladies' dressing rooms, and having those dressing rooms monitored? Would you want a woman, or would you want a man, or would you not care? Generally speaking, for moral concerns and modesty concerns, women would prefer, and I think men would prefer the same thing, they would prefer their like gender to be able to monitor those dressing rooms. The same way with toilet attendants and things of this nature. Generally, the BFOQ cannot be based on customer preferences. If that were the case, then it would be wide open for discrimination. Think historically, white customers preferred to only be treated by white doctors or white nurses, or simply because of race. Some of you are familiar with Hooters as a restaurant. I've been into one, but it was a long time ago, but I was impressed. The EEOC went after Hooters. It must have been about 10, 12, 13, 15 years ago, because Hooters was not hiring male servers. And so the EEOC says this is sex discrimination. And Hooters took the position that gender was bona fide occupational qualification. We got the uniforms, and that women would fit in. They weren't selling sex, but they were selling an appearance. And the EEOC spent a lot of money and a lot of time fighting them over it. Eventually, the EEOC relented. Benefits. Gender discrimination in benefits. Employers can't discriminate against women, or men for that matter, in employee benefits. Pregnancy, for example, qualifies as a disability for benefits, but not the ADA. It would be discriminatory in violation of Title VII if the company maintained a temporary disability benefit, but they specifically excluded pregnancy. It's been held that that is a violation. Pregnancy can't be excluded from employers' group health insurance plans or policies. Women cannot be paid less in retirement benefits under a defined benefit retirement plan, even though they live longer, and so that the total payout would be more. That was held to be discriminatory. And in a recent case in 2015, in Young versus UPS, the Supreme Court held that the Pregnancy Discrimination Act gave women a right of reasonable accommodation for their pregnancy if the employer also provided reasonable accommodation to men in non-ADA requirements. For example, a temporary disability. The ADA does not deal with temporary disabilities. Pregnancy is not, is not a disability because it's temporary. So, if an employer, as a matter of policy, puts injured workers who have a temporary disability or temporary maladies or injuries or something of this nature, gives them desk duty or sedentary jobs, then they have to do the same thing for pregnant women as well who can't perform. Let's talk about sexual harassment. What I say about sexual harassment, other than specifically about what sexual harassment is, also applies to other forms of harassment, age harassment, disability harassment, religious harassment, race, national origin, color harassment. All right. Same when I talk about the concept of harassment, when I talk about the concept of retaliation, when I talk about the concept of affirmative defense based on anti-harassment policies, these also apply to those as well. I don't think we need to talk about what sexual harassment is. I think everybody knows what it is. Lynn Martin, who's the former Secretary of Labor under George Herbert Walker Bush, said that sexual harassment is not just to make women comfortable in the workplace. It's so that the women and the men can have a workplace where each may grow and prosper. Who does it apply to? It applies to both genders, male and female. That should be free from that. It does not apply to sexual preference or sexual orientation, but a little bit later we're going to talk about that in a little bit more detail. Actions that may constitute actionable sexual harassment, well, we'll talk about some of those as well. And we'll distinguish between quid pro quo sexual harassment and hostile work environment. We'll talk about affirmative defenses, sexual harassment policies, and same-sex sexual harassment. All right, let's define what it is. They're unwelcome sexual advances, requests for sexual favors or other verbal or physical conduct of a sexual nature, and that constitutes sexual harassment when, one, submission to such conduct is made either explicitly or implicitly as a term of condition. A term of condition. 2. The submission or rejection of such conduct by an individual is used as a basis for employment decisions affecting the employee. If you don't do it, right? If you don't do this sexual activity or this conduct, sexually related conduct, then I'm going to do this. Or 3, such conduct has for the purpose and effect unreasonably interfering with the individual's work performance or creating an intimidating, hostile, or offensive working environment. Very broad. In all 3 of these, we're affecting the conditions of employment of the claimant. Who does sexual harassment apply to? Males and females, because of their gender, not sexual preference. Males or females, whether they're heterosexual, bisexual, or homosexual. Assuming that the perpetrator is not an equal opportunity sexual harasser. Look, it's not unlawful. It's certainly unethical, and it's certainly improper. Let's suppose that a supervisor likes to pinch, a male supervisor likes to pinch his female subordinates on the rear end, give them a pat on the rear end. Well, it's sexual. It certainly would be offensive. It would affect the condition of employment. As long as it's severe and pervasive, it would be unlawful. But what if he also did that for males? Pinch their rear end, grab some glute, maybe with a smile or something of this nature. Well, you're not treating males and females differently, and therefore, under the EEOC guidelines, it would not be unlawful. You would want to fire that person, but no lawsuit. Both employers and or the agents can be liable. Employers usually are the ones sued, but supervisors being as agents for the employers, can be liable. This is the case of Vance versus Ball State. And what do we mean by supervisor? Supervisor is one with the authority to hire and fire. Hire and fire and demote and transfer. These are the general characteristics of supervisors. If the perpetrator does not have those powers, then the perpetrator is not a supervisor for Title VII. Co-workers are not liable. They may be the cause, they may be the perpetrators of sexual harassment, but they are not going to be individually liable under Title VII. There are 2 traditional classes of sexual harassment. It is somewhat muddied now because of the affirmative defense in the cases of Farragher and Ellerith, but it helps to understand these 2 classifications. First, the quid pro quo sexual harassment. This is the worst one. Of the 2, this is the worst. This is where a supervisor conditions the granting of an economic or other job benefit upon the receipt of sexual favors from the subordinate, or punishes that subordinate for refusing to comply. We see this in the Showalter versus Allison Reed Group case. It has an egregious set of facts. Hostile work environment is the other form, and it's probably the most prevalent. It occurs when verbal or physical conduct of a sexual nature has the purpose or effect of creating an intimidating, hostile, or offensive work environment. intimidating, hostile, or offensive work environment. Hence, hostile work environment, sex discrimination. Now, this harassment must be either severe or pervasive. Let's take, for example, the Paula Jones case. Remember when Paula Jones, Arkansas State employee, sued Bill Clinton. This is when Bill Clinton was still the governor of Arkansas, and before he became president. Bill Clinton had allegedly had some highway patrolmen, state employees, to go out and find someone who might be interested in meeting him, and with some intimacy, and they found Paula Jones, brought him up to his hotel room, and then Bill Clinton was there without his pants, apparently without his underwear as well, and Paula Jones didn't like it, and she left. Now, it happened one time. They took no action against her. She continued to develop as an employee, getting raises and so forth. She filed a lawsuit under Title VII for sexual harassment, and U.S. District Court judge in Little Rock, a judge, by the way, who was later appointed as to the federal bench by President Clinton, found that it was such limited and temporal in nature that it didn't meet the severe or pervasive test. What acts could be sexual harassment? Unlawful sexual harassment. Gender-specific words, epithets, slurs, or profanity. For example, the use of anatomical parts to describe a worker. Curse words that are gender-specific. Derogatory remarks specifically about one's gender or negatively sexual stereotyping. Calling an employee a male employee words that calling him a fag or queer or something of this nature. See how I'm having problems uttering these. Keep in mind, and that's because sexual stereotyping is a violation of Title VII. Unwelcome sexual advances. Unwelcome requests, whether it be seriously or jokingly, for sexual favors or acts. Would you do this with me? Unwanted touching or intimacy. The grabbing of parts, etc. The touching of a female's breast or derriere. The posting of sexually offensive or degrading materials in the workplace. The sharing of sexual jokes, cartoons, the sending of them on the internet, of stories, etc. Discussions about sexual activities, books, movies, photos. Remember Justice Clarence Thomas's confirmation hearings, the comments that he allegedly made to a subordinate about watching the movie, the porno movie. What the heck was it? Long Dong Silver or something of this nature, or comment about a pubic hair on a Coca-Cola can or something of this nature. Keep in mind, The activities and combined have to be severe or pervasive. You can have same-sex sexual harassment. This is one in which the perpetrator and the victim are of the same gender. Up until, for the earlier years of Title VII, it was generally regarded as got to be same gender. And then the courts started splitting. Some jurisdictions say it has to be the same, it cannot be the same gender. Some jurisdictions saying it could be the same gender. Some saying, well, we don't know if it can or can't be, but if it's a homosexual harassing a heterosexual, then it can be. And so it wasn't until the U.S. Supreme Court decided the case in Unwelcome versus Sundowner Offshore Services, Inc. In 1998 that where Scalia wrote the opinion, in a 9-0 decision, that there was nothing in Title VII that prohibited same-sex sexual harassment. And they did not have to look at the intent of the legislators because the statute itself did not say anything otherwise. It was an egregious set of facts, one that an employer surely would not want to go before a jury. I wrote a paper on it. I'm not sure. I think the paper, I'm sure it is. My paper was written, I think, in 1999 about Unwelcome versus Sundowner Offshore Drilling, the outer limits, and its own Moodle rooms on my folder, my articles folder. Now, in that case, in that Unwelcome case, the court was specific that its decision on same-sex sexual harassment did not mean that sexual preference and sexual orientation was covered by Title VII. The fact is, they said it was not. But there are some jurisdictions that have basically taken the same set of facts when it was clear that the motivation for the sexual harassment and the mistreatment of a sexual nature that affected the condition of employment, it was clear that it was based on the victim's sexual preference or sexual orientation, as in the case of Renee versus MGM Hotel, and Renee, who was gay, working as within food services as a waiter for MGM Hotel in Las Vegas. He was gay, and his co-workers knew it, and they mistreated him and calling him a lot of names and treating him differently and so forth in his suit. And the Ninth Circuit Court of Appeals says, because they did not treat any females that way, they clearly discriminated against Renee because of his gender. And because they treated him differently because of his gender, then the court did not have to consider the effect of sexual preference or sexual orientation. And keep in mind that this is also what was said, similar rationale in Unwelcome, Scalia's opinion. There was one in which guys were working on a dock, a small team were working on an offshore drill, and they were out there a whole week all by themselves, and they would watch porn and do what men do when they're away from families and so forth, and act and cut up. And they didn't do any of this stuff to women. Women were not treated badly, so they only did it to the male. And because only a male was, for example, violated with the bar of soap and touching and having a supervisor put his penis on Callie's neck and arm on a couple of occasions. They violated him with bar of soap in the shower. They said they only did it for gender because he was a male. And they said that the perpetrator said that we don't know if he's male, whether he's gay or not gay. Although he was effeminate, there was no finding of fact that they did it because he was gay, which was a bad decision on their lawyer's part. And so they found the liability. So it basically opened it up. The reality of it is, what fool in his right mind would do those things to a woman? What male would do that? Now, you may do it in jest. It's a cruel jest, a harmful jest to do that to a male, but to a woman, I mean, that's hard jail time. I mean, this is no teen movie like that when it comes to women. It would be hard jail times for sexual battery. And that's why you would treat males and females differently. But I think we've opened it up. At some point, we're going to find a difference between. We're going to get Title VII is going to be changed to add sexual preference or sexual orientation, like 21 of the states have done. Some potential problem areas. What happens when a consensual relationship becomes non-consensual? Right? When the yes becomes no. This is why a firm may consider non-fraternization policies. A corporate culture degrading to women. A male-dominated industry, for example, as in Ford Motor Company's 1999 case. Or when management is dominated by a foreign culture where the women are held in lower esteem than in the U.S. And this is like the Mitsubishi case in Illinois. They were socked with $34 million of civil penalties, right? Damages to settle a claim for 300 women at the, I think it's the Peoria plant. Another potential problem, and it's a major problem, is retaliation. Retaliation is worse than the underlying act. Retaliation can it manifests itself. It shows the malice, and therefore it can be the basis for punitive damages. The case of Thompson versus North American Stainless, a U.S. Supreme Court case from a few years ago, says that if there's retaliation against a third person, where the employer who has a complaint filed against it, a sexual harassment complaint filed against it, when they take action against a third person rather than the complainant. And in this particular case, they took it against the boyfriend of the complainant, right? So they retaliated against the boyfriend rather than the complainant herself. Court held that this was unlawful retaliation and sex discrimination under Title VII. Let's look at remedies for sexual harassment. And by the way, these remedies also go to other forms of harassment as well. Equitable damages, meaning you can get an injunction against the employer from further sexual harassment. There can be punitive damages. Can be lost wages, economic damages, if the employee is terminated under a quid pro quo sexual harassment, or is given a pay cut, demotion, or is constructively discharged. Now, I use that term constructively discharged because anytime you see the word constructive, it means not really, but substantially. If a person has been constructively discharged, that person has been put in a situation where that employee has no choice but to leave on his or her own. Work there is so unpalatable and so unacceptable that you have to leave. It's a hard thing to prove, but it's there. It's available. The pain and suffering can be limited by statute depending on the employer size. As we see here, small employers will have a lower amount of pain and suffering. These are non-economic damages, and these are the emotional damages. And keep in mind that this is going to be per employee. So what if you got a big company like a Mitsubishi assembly plant? You got 300 victims. Well, 300 times $300,000, that's a lot of money, isn't it? There can be injunctions and cease and desist orders. There can be attorney's fees and costs, which are common. And the EEOC may have, or the court may have oversight on sexual harassment policies and monitoring effects. This is the case in Showalter versus Allison Reed Group. An employer needs to maintain a good sexual harassment policy. The policy needs to be written broad enough to cover all of the forms of harassment: disability, race, color, national origin, religion, age. Kind of a one-size-fits-all, so to speak. It gives protection for all. And the reason for this is, first, it lets the employees know what their obligations are, lets the workers who might be victims know what their rights are, and it may a good sexual harassment policy, if it's effective and maintained and used and followed, may work as an affirmative defense in a sexual harassment lawsuit. We have two U.S. Supreme Court cases from 1998, and these are major cases. They came in as companion cases, meaning similar issues, just a little bit different between the two. And what the Supreme Court did in 1998 is to give a gift to employers, and this is a gift of an affirmative defense. Now, an affirmative defense is a legal defense to a claim, to an otherwise valid claim, legal claim of the plaintiff. But the affirmative defense must be pled. It either has to be pled in the answer or in a motion. But it's affirmative. Basically, the defendant only has this defense if the defendant makes use of it. There is a limitation, however, and that is there is no affirmative defense if the victim of the sexual harassment has suffered an adverse employment action. Put another way, an adverse, tangible job action. Something has happened. something negative has happened to this employee, such as discharge, demotion, or undesirable reassignment. Let's look at this affirmative defense, and this is major. This is something that you clearly want to learn. An employer or an agent, supervisor as well, that's had a claim against it before the EEOC first. And by the way, in a sexual harassment claim or any Title VII claim or any ADA claim or ADEA claim, an administrative requirement in order to have standing to sue is that the victim must file a complaint within the statutory guidelines, the statute of limitation guidelines, must file a complaint with the EEOC. And that usually is you have to file a complaint. The victim has to file the complaint within 6 months of the unlawful action. Within 6 months of the unlawful action. Now, there's an extension if the EEOC does not have an office, say in the state, because it's a real small state. When I talk about the 6-month statute of limitations, what happens if you have a continuous discrimination, like continuous sexual harassment? Well, the 6-month statute of limitation goes to the end of it. It starts at the end of it on a continuous. So you have this affirmative defense. The employer and the agent, supervisor, has this affirmative defense against a lawsuit for a claim for sexual harassment, race harassment, national origin, any of those. If the employer can demonstrate that it took reasonable steps to prevent and promptly correct any sexual harassment. Those reasonable steps would include creating an effective anti-harassment policy, making employees aware of the policy, and promptly investigating claims of harassment. The employee has to know. The employer must follow the policy. And the employer must prove that the employee unreasonably failed to avoid the harm or failed to follow the employer's sexual harassment policy. They didn't tell the sexual harassment monitor or director, typically HR, about the sexual harassment. Because if the employer does not know about the sexual harassment, how can the employer take preventative measures to investigate and take corrective actions? Keep in mind, the basis of holding the employer liable is under the doctrine of vicarious liability for aiding and abetting the sexual harassment. If the employer knows of the sexual harassment and does nothing, then the employer is aiding and abetting the sexual harassment. If the employee does not tell the employer about it and the employer has no reason to know of the sexual harassment, then how can the employer stop it? So what's good policy? Define sexual harassment. Unambiguously prohibit sexual harassment conduct and provide for discipline against the violators. Now keep in mind, discipline does not require termination of harassers. There can be a progression, lesser penalties to major penalties. For example, first might be, for simple harassment, it might be a letter of reprimand. It may be a suspension from work. It may be a demotion. It may be termination. But the sexual harassment policy must advise the victims that there are consequences. The policy also prohibits retaliation against persons who claim sexual harassment. A good policy will provide multiple avenues for complaint. For example, what if the sexual harassment policy says that if you've been a victim of sexual harassment, you have to report this sexual harassment to your supervisor? Well, what happens if there is no other person? What if there's no alternative? And your supervisor is the one who's doing the sexual harassment? It would be a weak policy and probably fail in such case. So what you can have is you can have other persons within the organization. You can have anonymous complaints. The policy should assure prompt investigation and disciplinary action, and assure the privacy of complaints. And then the employer needs to make sure that all employees are aware of the policy. What's a good thing? When an employee is hired, someone from HR should discuss within the employee handbook the sexual harassment policy. The employee needs to know that policy, have a copy of that policy, or know where to find it with easy access. And it would be a good thing also to document this through having the employee sign that he or she has received a copy of the sexual harassment policy and has read and understands it and agrees to comply with it. And then put that signed copy of acknowledgement in the employee's personnel file. All right, let's briefly go into pregnancy discrimination. Under Pregnancy Discrimination Act, employers cannot discriminate against women who are pregnant or who desire to become pregnant or who choose not to become pregnant. The general test is, can the woman perform the work assigned? If she cannot perform the work assigned, then there is no obligation to keep her working. You don't have to pay her if she can't work. Keep in mind that Young versus UPS case that puts some limitation here. A woman can't be fired for being pregnant, and pregnancy is not a disability under the ADA because it's temporary. A woman can't be forced to go on 2 maternity leave as long as she can still perform. That Young versus UPS comes into play. After maternity leave, a woman has the right to return to her old job if it is available. Now, the employer has a right. If the employer needs to fill that position because it's an essential position, the employer can do that. If her old position is not available, then if there's a comparable job, then she has a right to that. The Pregnancy Discrimination Act does not prescribe a minimum amount of maternity leave. Keep in mind that some states have their own version of the Pregnancy Discrimination Act, and they may require In fact, they may very well limit this ability to terminate a woman because of her pregnancy. It may very well be, and I think Tennessee does that. They've amended their Pregnancy Discrimination Act, in which you cannot terminate a pregnant woman who goes on to onto maternity leave. If she willfully chooses not to return, then you can terminate her. But it's a policy that's very similar in effect to Family and Medical Leave Act that prohibits termination of a worker on family and medical leave. Similar to the Family and Medical Leave Act, the Pregnancy Discrimination Act does not mandate paid time off unless the employer has such a policy. For example, a temporary disability policy would cover it. I think there probably are more, but in last count, 5 states now had mandatory temporary disability income benefits. This extends beyond the requirement of all workers have this right. This specifically deals with pregnancy in and of itself. I believe California's is funded by additional taxes on all employees. Right? In my situation, I would find that offensive. That I would pay goes on beyond my wife and I are beyond the child rearing years, or the child producing years, I guess. At least she is, and that we would be paying taxes for someone else to have children. But that's a policy for that particular state. The first state, by the way, the first jurisdiction in the U.S. or under U.S. law to do that was Puerto Rico, that had a disability for pregnancy. If after maternity leave a woman does not return to work when her physician says she can return to work, she can be terminated, unless, of course, she's still on FMLA leave and she still has time available. The U.S. is generally regarded as the worst or second worst. 10 years ago, 12 years ago, it was the only 2 countries that didn't have some kind of paid maternity leave was the U.S. and Sierra Leone, and we're far apart on that. But the question is, the U.S. does not have the paid leave, but where would you rather live and work? You can consider Sweden's policy. Sweden has a very, very, very handsome maternity policy, pregnancy leave policy that would bankrupt the U.S. or require the taxes on employers to be so high, or employees to be so high, or taxpayers to be so high that it would be unworkable. Sweden, last chance, Sweden's policy was that a woman was entitled to compensation for her time off for pregnancy, about in the neighborhood of about 50% of her pay, and it would last for up to 18 months. Males, fathers, for example, also had a mandatory 45 days off work for the birth of the child. The new mother also had an option after that 18 months of going 5 years as a part-time worker as opposed to full-time worker, and she was protected during that time if she so chose. Very, very costly policy. Equal pay. This is equal pay for equal work, substantially equal work. You can pay men and women differently. If the difference in the pay is because of skills, effort, responsibility, working conditions, a seniority system, a merit system, or quality or quantity of production. I don't want to talk about comparable worth. It is a topic that's good for ethics. It's something that women's group would like to see, but I don't think nobody's smart enough to put it in effect. This is equal pay for comparable worth. It basically would require a consideration of what is predominantly male jobs and what's predominantly female jobs, and equating the predominantly female jobs to predominantly male jobs that pay more. And with that, we will end the discussion of sex discrimination. For week 6, we'll first look at corporate governance, then followed by discussion of the Securities Act of 1933, and then the Securities Exchange Act of 1934, and the Jobs